see Deadpool and Wolverine on opening night again. And this had absolutely nothing to do with Blake or Ryan. Just me being a genuine fan of movies, I went to the Alamo Drafthouse in Austin. The parking lot was packed, I barely managed to find a seat, and every single show was sold out. It was an incredible feeling to arrive at a movie theater that was full of energy, with people talking and buzzing before and after the show. That shared experience of watching a movie together in a theater is truly something special, and I hope more and more people continue returning to cinemas for that very reason. Now, shifting gears. Do you all think the attorneys representing Justin Baldoni may have indirectly acknowledged or supported something I said? Perhaps with a subtle shout-out or even a metaphorical fist bump, because they argued that they weren't expected to have a crystal ball to foresee that the Daily Mail reporter would suddenly alter his previous statements regarding Leslie Sloan in the months both leading up to and following the lawsuit. Do you remember when I mentioned that Daily Mail journalist James Vizuka was in the process of attempting to retract a statement he had made? That he had previously said something completely different, and there were rumors he was pressured into signing the new statement under the threat of losing his job? Well, that's exactly what seems to have happened. He signed a declaration based on an alleged promise from Daily Mail that he wouldn't be fired, and yet, he absolutely was. He lost his job just a few weeks ago. That same declaration was then used by Leslie Sloan in her defense, attempting to argue that the lawsuit filed against her was groundless. Her legal team claimed that because the reporter changed his story, relying on his original statement was negligent and unprofessional. Their position was that any competent attorney should have known better than to build a case using those statements. But the legal team pushing back on this had a strong response. Alan Goff is an extremely sharp attorney. There are several other lawyers from the Friedman law firm working behind the scenes on this case that most people don't even know about. For instance, Ellen Gaff, a Pepperdine graduate, and Jason Sunshine, a Columbia Law School graduate. And let me emphasize, Columbia is an Ivy League school, and its graduates are among the most sought-after legal professionals in the country. Michael Gotadl, who represents Blake Lively, is a Harvard graduate. While Lively's team is aggressive and willing to go to great lengths in this case, the attorneys representing Wayfair seem more focused on the rule of law, choosing to build their case using solid legal arguments rather than sensational tactics. At this point, Ellen Gaff appears to be emerging as one of the lead attorneys. She's the one who filed and won the motion to compel Vanzin to produce key documents. She also responded to the sanctions motion filed against Blake and Ryan. Most recently, she filed the opposition to Leslie Sloan's request for attorney's fees. And none of this seems like a coincidence. Gaff's legal strategy is clear, focused on presenting strong arguments, staying away from personal attacks, and relying solely on facts and law. In her latest response, Gaff addressed Sloan's argument that the lawsuit was frivolous, that it should never have been filed, that it was negligent from the start, and that the legal team should have known James Vizuka never alleged sexual harassment, SH, or sexual assault, SA. Gaff presented several counterarguments as to why Sloan's request for attorney's fees should be denied. One of the arguments she made was that Sloan didn't bring an affirmative claim, meaning she didn't file a lawsuit herself, but rather filed a motion. Another key point Gaff raised involved the Second Circuit's stance on anti-SLAPP statutes. As I previously mentioned about a month ago, the Second Circuit Court of Appeals ruled that California's anti-SLAPP law does not apply in federal court within their jurisdiction. This legal precedent played a central role in the case. They argued that New York's anti-SLAPP law conflicts with several federal procedural rules, specifically Rules 12 and 56 of the Federal Rules of Civil Procedure. Under Rule 12b, the burden for a pleading is to allege enough facts to present a claim for relief that is plausible on its face. Rule 56 allows for summary judgment only when the moving party demonstrates that there is no genuine dispute over any material fact and that they are entitled to judgment as a matter of law. Much of what Ellen Gaff relies on involves case law and rulings from the Second Circuit and other jurisdictions that address whether it is even permissible to award anti-SLAPP attorneys' fees in federal court. Their argument is that it is not permitted and that most of the provisions under New York and California anti-SLAPP statutes do not align with federal civil procedural rules. Furthermore, they argue that a dismissal under Rule 12b 6. Does not automatically imply that a claim lacks any substantial basis in fact or law. Sloan had asserted that the claims were frivolous, but after arguing that anti-SLAPP doesn't apply, the opposition brief goes on to say that the court should not award attorneys' fees under its inherent powers either. While courts do possess inherent power to sanction parties for bad faith conduct, this power does not extend to simply making the prevailing party whole by awarding attorneys' fees. They point out that Sloan's notice of motion made no request for sanctions. While there are exceptions, federal courts can sanction a party or attorney using their inherent authority to manage proceedings. These powers are used sparingly. Courts typically only invoke them in the most extreme cases, where the moving party can show by clear and convincing evidence that the other party acted fraudulently or in bad faith by filing a frivolous claim for an improper purpose. They argue that two findings must be made to grant such sanctions. 1. The challenged claim must be entirely without a colorable basis, and 2. The claim must have been brought in bad faith. In this case, they contend that neither requirement has been met. The case was dismissed under Rule 12(b)(6), meaning the claims were inadequately pled, not because they were entirely lacking in factual or legal support. Their position is that the claims had a colorable basis. They were supported by some legal and factual foundation when viewed in light of what the plaintiffs reasonably believed at the time. The standard is whether a reasonable attorney or party could have believed that the facts supporting the claim might be proven in court, not whether the facts were definitively established already. Essentially, they argue that based on the available evidence, a reasonable attorney could have believed the claims might hold up under legal scrutiny. They reiterate that the original claims against Sloan included allegations that she collaborated with Lively and Reynolds to spread false narratives to the New York Times, suggesting that Justin Baldoni had engaged in sexually inappropriate behavior and that he and others retaliated against Lively for reporting this alleged misconduct by attempting to destroy her reputation. They further claimed that Sloan herself made false statements to press outlets alleging that Baldoni had committed sexual misconduct. However, the court did not dismiss these claims for being wholly baseless, but rather because the plaintiffs failed to adequately allege Sloan's direct involvement in Lively's sharing of the draft CRD complaint with the New York Times, or that Sloan independently stated to a Daily Mail reporter that Baldoni assaulted Lively. Instead, the court noted that Sloan may have simply repeated Lively's account, one that she had no reason to disbelieve. At this point, they highlight the declaration, the one previously discussed, calling it questionable and potentially coercive. This is where I even get a subtle shout-out. Sloan pointed to the declaration submitted by the Daily Mail reporter, disavowing that Sloan made any such statement. However, the same reporter, James Vizuka, had earlier claimed quite the opposite. In prior communications, Vizuka had recounted that during the summer of 2024, Sloan had been saying that there were issues on set and that everyone hates Justin. However, at that time, she had not suggested, even subtly, that Baldoni had engaged in any form of sexual misconduct toward Lively. In fact, Sloan had previously told the reporter that the tension on set had nothing to do with Blake. But after the New York Times article was published, the reporter noted that Sloan had changed her account and was now saying Blake had been sexually assaulted. He pointed out the stark discrepancy between what Sloan said then and what she was saying now, questioning why she hadn't mentioned anything back in 2024 if that had truly been her position. The reporter's more recent disavowal of his earlier statement was described as not credible. He now claims he meant to say sexually harassed and that he was referring to the allegations in Lively's CRD complaint, not to any direct conversation he had with Sloan. However, his prior statements were not ambiguous, and his new explanation lacks coherence. At the time of the original complaint, the Wayfair parties had every right to rely on his earlier, clear statements. They were not expected to anticipate that he would later recant or revise his account. Therefore, including the reporter's statements in the amended complaint was not knowingly false, nor did it stem from a lack of diligence by the Wayfair parties. Rather, the claims failed because they didn't adequately allege Sloan's requisite state of mind, specifically, that she acted with actual malice. The court held that there were insufficient allegations supporting an inference that Sloan knew or recklessly disregarded the falsity of her statements. Notably, the complaint did not allege that Sloan was even present during any interaction between Lively and Baldoni. Failing to meet the high bar of proving actual malice does not mean the claims were baseless. On the contrary, there was circumstantial evidence suggesting that Sloan may have known the allegations were untrue, namely, her failure to mention them in summer 2024 while disparaging Baldoni to the press, long after the alleged incidents had taken place. Additionally, there was no evidence that the Wayfair parties pursued their defamation claims in bad faith. Sloan argued that they filed suit to distract from their own misconduct or to silence her, suggesting the lawsuit was a mere publicity stunt. However, she offered no supporting evidence for these assertions. The Wayfair parties filed suit in the wake of what they allege was a coordinated media attack orchestrated by Sloan alongside Lively and Reynolds, resulting in their reputations, careers, and business prospects being decimated, including damage to the viability of their production studio. Their defamation claims center on proving the falsity of the allegations at trial in the Lively action. And crucially, nothing in the court's order dismissing their defamation claim undermines that defense. They assert that they relied on what Vizuka said at the time, when he recounted that Sloan had made no mention of sexual assault. Now, Vizuka claims he was referring to the CRD complaint, but they highlight that in his original statement, there was no mention of the complaint, just Sloan's purported words. They argue they cannot be faulted for not predicting a reversal in testimony, emphasizing they didn't have a crystal ball. Without saying it outright, they suggest to the court that Vizuka's updated statement is suspect and may have been the result of external pressure. This ties into your previous reporting that Vizuka was allegedly coerced into signing his new declaration under threat of job loss, and that there were inaccuracies in the document. According to your sources, he wished to withdraw the statement due to feeling intimidated and coerced. After signing it, he was allegedly retaliated against and ultimately fired by Daily Mail, reportedly for changing lawyers and asserting whistleblower protections, including his right to testify freely. As for whether the Wayfair parties will appeal, it's unclear. While they have 30 days to file a notice of appeal, there are exceptions. An attorney you spoke with explained that if Wayfair prevails in the Lively case, if it is dismissed or they are found not liable, they may be able to appeal the dismissal of the defamation claims based on evidence uncovered during discovery. That would allow them to potentially challenge the dismissal after a final judgment is entered in the other case. Appeals cause procedural delays, as everything pauses until the appellate court weighs in. Since the parties are currently negotiating discovery timelines, and Wayfair seems opposed to delaying discovery, it seems unlikely they would appeal right now. But that doesn't mean they won't appeal later, or pursue separate lawsuits if new evidence comes to light. They're facing multiple legal hurdles due to applicable privileges and standards, but from their perspective, they relied on what they believed was valid evidence from their client Melissa, including text messages. Vizuka didn't originally specify that he was referring to the CRD complaint. He simply said Sloan was now claiming sexual assault, which she hadn't mentioned before. The judge ultimately found Vizuka's clarification credible and noted that no one had asked him for clarification prior. But Wayfair's argument is that they were acting in good faith based on what they knew at the time, and if Vizuka was coerced, as your reporting suggests, then it's understandable why his new statement raises red flags. So again, you're welcome, Wayfair. And a final note. Don't subpoena me, Blake. I've heard rumors you're trying to delay discovery. All right, everyone, drop your thoughts in the comments. Be sure to like this video, subscribe, and hit that bell icon so you never miss an update. Thanks for watching. Bye. Waving hand.